2020 meeting of the Mendocino County Civil Service Commission. Roll call, please.
Chair Ward,
Here.
Commissioner Poplawski,
Harry, you're on mute.
you're on mute, Commissioner Poplawski. I'll come back to that.
Morning. Can anybody hear me?
Yeah,
Yes,
I can't hear anything. I do.
And Commissioner Harden, absent by prior arrangement. And then we're ready to move to the minutes.
Ready to move forward?
They can hear me.
Terry, can you hear us now? Morning, Terry.
So you could close it and try opening it again once did you have to change the speakers?
I did change it.
Yeah, just close it and,
Close one. This?
yeah. Please leave it and restart.
I wasn't asked if I was here, but I'm here.
And same with me. I'm here. Can't you see me?
that's okay. They know it. They can see me.
We move on, or we're going to wait for Mr. Poplawski? Donnie.
I'd give it a sec to re-engage. He was just,
Okay.
would be my call.
Yeah, I agree.
Well, maybe more than a second, but.
Hey, Commissioner Poplawski, you're on mute. Harris, Commissioner Poplawski, you're on mute. Can you hear us now?
Actually, you could hear them.
I can hear you. I can see me.
Okay, approval of the minutes.
You good? Yeah, I'm good. I am being.
I'll
Okay,
move to approve the minutes as provided.
I'll second.
We'll do the approval of minutes by roll call. Chair Ward,
Yes.
Commissioner Poplawski,
Yes,
Commissioner Evian,
Yes,
Commissioner Michelle.
Yes,
Next item on the agenda is public expression. This is an opportunity for the public to address the commission on matters not listed on the agenda. Individuals wishing to address the commission under public expression are welcome to do so via email, Zoom, or voicemail message. Have we received anything from the public? Donnie?
We do have Public Defender Jeffrey Aaron's item, but it will be heard during the actual item, but it is on there under public expression because that's where we put it on the agenda.
So noted. Item number 4 on the agenda would be the opportunity for the employee organization representative to present information requests to the commission. I don't see anybody here. Let's move to closed session.
We have no closed session.
You want to introduce the item?
For number 6,
Attorney classification, State Bar of California Provisional Licensing Program.
yes, good morning. Johnny Cranmer, Human Resources Manager. This item came before the commission during the November 18 meeting. It did not pass pending further discussion with all the affected departments. Public Defender Jeffrey Aaron was unable to attend as he was in court, and he also requested that Human Resources bring this back to the commission so that he could participate in the discussion. Alternate Defender Patricia Littlefield also did not attend the November meeting. District Attorney David Eister attended the November meeting and stated the reasons why he would not support the program and would not be interested in utilizing the program. The provisional licensing program was announced on October 22nd via news release by the State Bar of California. I've provided the link, and also attached to my item were the frequently asked question sheet. The sheet has been updated several times. I just looked at it a few minutes ago, and the most current version is the December 7th version that was attached to your items. This program is slated to end on June 1st, 2022, unless it's extended by the Supreme Court. During the meeting, Human Resources proposed that rather than changing the class specs to reflect the temporary program, that the commission approve us to be able to announce participation in the program on the recruitment announcements when the requesting department wishes to consider candidates under this program. The blurb would on the recruitment folder would explain that that we are participating in the program and that they need to follow and be eligible under the program in order to be considered. And then for process during the temporary provisional licensing program, all of the applications will be screened for the required education and experience requirements without regard to licensing, with those applicants meeting those education and experience requirements being invited to further examination. Non-licensed applicants who otherwise meet the minimum requirements and pass the examination conducted, whose name are placed on an eligibility list, must be provisionally licensed by the state bar before they can be hired by the county as an attorney. Having one's name placed on an eligibility list does not guarantee hiring. Rather, it entitles the applicant to a selection interview with the department when their name appears among the top ranked candidates. This interview may lead to additional interviews or the referral and background process for some candidates. But if an unlicensed candidate is selected and the department may, under the provisional licensing program, make the conditional job offer that would allow them to proceed through the licensing process, any candidate that is not successful in obtaining the provisional license for any reason would be removed from eligibility list for further consideration. If the commission approves waiving the license in order for otherwise qualified candidates to participate in the recruitment and selection process in conjunction with the state's provisional licensing program, utilizing this program would be at the election of the requesting department and would not be required of any future recruitment by the same department while the program is in effect. The recommendation is that if the commission approves waiving the license requirement in order for counties to participate in the temporary program, that it is recommended that the commission approve the proposed recruitment language regarding the program or as modified by the commission without making modifications to the class specs. Thank you. I'm available for questions if you have any.
Can we hear from Ms. Cole Wilson? Still
I
on
have
mute.
I have a question.
Go ahead,
Yeah,
Sharon.
I'm sorry, I don't have any questions at this time.
Oh.
I'm submitting on the letter that Mr. Aaron had written today in his absence, and he apologizes that he can't be here.
Will you please, Jen, for the benefit of the public, will you please read Mr. Aaron's letter?
The whole letter that he submitted for today?
Yes.
Oh, yes.
Thank you.
Yes, actually, I will. Dear commissioners, thank you for putting this issue on your agenda. Please excuse my absence at the November 18th, 2020 hearing. Maybe I should introduce myself first. My name is Jan Cole Wilson. I'm sorry. I'm the Assistant Public Defender in Mendocino County. And I'm appearing on behalf of Mr. Aaron today. Please excuse, this is the letter from Mr. Aaron. Please excuse my absence at the November 18th, 2020 hearing. My absence was not because I thought the matter was unimportant. To the contrary, I had requested Human Resources place the item on your agenda on November 28th, 2020, and again on December 16th, 2020. Regarding the original November 18th, 2020 hearing, I had noticed that Human Resources was in favor of the proposal. I was never contacted by the district attorney or anyone else and told that there was any opposition to the proposal. So not thinking that there would be any opposition and having no less than five matters on the morning calendar that day, including 2 murder cases, I went to court to represent my clients. Today, I started a preliminary hearing with 5 defense attorneys in a multiple life sentence case. We started at 10:30 a.m. and it is still in progress. The prosecutor estimates a minimum of another 2 to 3 hours. The court ordered all attorneys to be back at 8:30. I asked the court to order that our preliminary hearing begin after the commission hearing, but the court did not want to inconvenience the attorneys, the witnesses, and the defendants. So unfortunately, I will again miss the hearing. He's talking about today's hearing. As for the matter before the commission, there is little controversy about the provisional attorneys program. I listened to the first hearing conducted by the commission. There are a number of things that the commission should know about this program that were not discussed at the first hearing. The entities that determine what is not ethical in California are the California State Bar and California Supreme Court. There have been no negative decisions by any courts in California about the provisionally licensed program. Indeed, the California Supreme Court approved the program, and the California State Bar itself designed the program. It is a detailed and thoughtful program that protects the public, the lawyers, clients, and the profession through careful, measured legal procedures. See fact provisional licensure program in California Supreme Court's news release attached here too. Having been created by the California Supreme Court and the California State Bar, it is per se ethical. Having been created by the California Supreme Court and the California State Bar, it is per se ethical. Provisionally licensed attorneys are listed on the State Bar website and can be searched by the public. Many firms with stellar reputation in the state's legal community employ provisionally licensed attorneys. The commissioners can search for themselves, as can the general public, to see the caliber of firms and agencies that employ these lawyers. And he cites a link. You can go to calbar.cal.gov/provisional/dot. Government or quasi-government offices such as the Los Angeles County Public Defender, the San Mateo County Council, the District Attorney for Alameda County, and the District Attorney for Contra Costa County all employ provisionally licensed attorneys. I believe that there are more government agencies that employ such lawyers, but I had limited time to research the issue this evening. I can assure the commission there would be no diminution, excuse me, I'm sorry. Thank you, Mr. Eister, of the stature of the public defender's office in this county if such a lawyer would appear on our matters. First, the lawyer would be supervised by an experienced deputy. Second, the lawyer would only appear on minor misdemeanors. And third, the lawyer would be thoroughly trained before appearing in court. In fact, one could argue that having an experienced deputy supervising a provisionally licensed lawyer gives the client more protection and more representation than if the client were represented by only one new deputy public defender. Today, I personally spoke with Ms. Littlefield, the alternate public defender. She cannot appear at the hearing because she is an attorney in the same preliminary hearing that Mr. Aaron is. She does not oppose this program, although given that her office is so small, she doubts that she will be able to use it. That brings me to my final point. The public defender is not intending to hire provisionally licensed lawyers at this time, but we would like the opportunity to expand our applicant pool. We are hiring now and we only have had 5 applicants for interviews. I appreciate that district attorney has many lawyers applying to his office, but in the 2 short years I have been the public defender, that has not been my experience. In part, this is because of the relatively lower salaries offered in our county, in part due to our location, and in part due, I believe, to the nature of our work. Our lawyers are hardworking and idealistic, but it is difficult, challenging, and frankly, emotionally exhausting work. It is most definitely not for everyone. The cases and clients whom we represent are, for many lawyers, unpleasant, if not frightening. We simply want to increase our county's ability to reach as many young lawyers as we can and show them the advantages of working in a wonderful county such as Mendocino and in what I believe is an excellent and supportive public defender's office. I urge you to permit the amendment of the civil service rules so that provisionally licensed lawyers may, but are not required to be considered by county law offices. Thanking you in advance for your kind consideration. Sincerely, Jeffrey Aaron, Public Defender. Thank you.
I have a couple of questions you may or may not be able to answer. I'm sorry, Mr. Aaron isn't here, but it's understandable. On the second page of the letter, 3rd paragraph, it talks about representing minor Misdemeanors, is there a codified definition of a minor misdemeanor? Is that a subjective?
I think that might be subjective. I would say a minor misdemeanor would be something like a petty theft. It could be something like we represent a lot of clients who are charged with driving on a suspended license. Those are still misdemeanors. A first offense, driving under the influence of alcohol, a first offense might be considered a minor misdemeanor. Those kinds of things are considered minor misdemeanors. And we have our misdemeanor attorneys have upwards of 80 to 100 open cases at one time. And so we have a lot of those. So there would be there are a lot of minor misdemeanors. You can get more serious misdemeanors when you start getting multiple DUIs or domestic violence cases that are still misdemeanors, but minor misdemeanors run in the first offense DUI or driving on suspended license, those kinds of things.
All right, so that leads me to the second point. The first lawyer in that same paragraph, first lawyer will be supervised by an experienced deputy.
Correct.
And it goes on to say that they would be thoroughly trained before appearing in court. If the public defender's office obviously is overwhelmed with cases and lack of staff, who's going to have the time to thoroughly train a non-credentialed attorney? Is there going to be outside programs sponsored by the defender, or is it just a pep talk before court?
Oh, it's not just a pep talk, but we do the best we can, because a lot of our misdemeanor attorneys are fresh out of law school too, or not fresh out, but they're in a training program as well, because as anybody who is in the legal field knows, you don't get trained to go to court out of law school. And so a lot of our attorneys have to come in and we train them. Like I've been a supervisor with the municipal court or the muni court deputies, having been attorney for 30 years myself here in Mendocino County. So, and a lot of it is on the job training, but we supervise in court when they first start going. And some of our muni court attorneys have been there for upwards of a year, 2 years and they're there. I mean, it's not like we just send them in after we've, gone over the cases with them. They're there in court with them.
My other question would be for Johnny, the restriction for these non-credentialed attorneys to only handle misdemeanors. Is that in the job description? Could it be put in the job description?
No.
Well, if it is the desire and the direction of the commission that we do modify the job description, then it would be put in there. But I think already the job description for the lower level attorneys, because there's 4, there's a 1, 2, 3, 4, and the 1 is your entry level and the 4 would be your most advanced. Those job specs do have brief discussions about the kind of cases they handle.
But these are not attorneys yet. They passed the, I don't know if they haven't passed the bar yet, so they're not attorneys. So I think it's apples and oranges.
If they're approved through the licensing program, the provisionally licensed program, they would be then the class specs that if they're hired as a deputy attorney 1, the class specs that they're hired under would be their job description. And like Ms. Cole Wilson says, they do have a training program. The entry level, they are under closer supervision than each progressing level, and they handle progressively more complex cases as they move up through the series of the 1, 2, 3, and 4.
Right. So Also, another question I have is there a provision within the job description of the provisionally licensed attorneys that they pass the bar within a certain set amount of time? When I became building official at Healdsburg, I had to get a building official certification within 6 months of employment. Everything like that in the proposal.
Right now, the job description says for all 4 levels that they must be a licensed attorney in the state of California. What we're asking for is that rather than modify the job description for the temporary program, that we just include that as I wrote it in my memo in the recruitment flyer. But again, if the direction from the commission is to modify the class specs to incorporate the temporary provisions, then that would be at your discretion and vote.
That's all I have.
I have a couple questions. If a licensed attorney would be in court as well as with the provisionally licensed attorney, it doesn't seem like that is going to save the public defender's office a whole lot of time. And so I'm wondering if the main purpose of this is, as Mr. Aaron referenced, to expand the applicant pool. Can you speak? I mean, he said that there were only 5 applicants for a position that was open, so that's my first question. And I'm wondering if the small number of, he also referenced the low salaries in this county, which could contribute to a smaller applicant pool. And I'm wondering if if you have any information about how Mendocino County's salaries compare to comparable counties.
Is that directed to me, ma'am?
Yes, please.
Okay, yeah, I don't have that information at my fingertips, but I do know that there is always licensed attorneys in misdemeanor court, always. And even if we had provisional attorneys in there, we would be able to perhaps have less licensed attorneys and move them into another department, but there is always licensed attorneys in municipal court, not municipal, but in misdemeanor court. So perhaps 2 licensed attorneys that could be used in low-level felonies could be used there, and then we would have provisional attorneys, but always a licensed attorney in the court. So it could be used to ease up. As far as salaries and all of that, I mean, I can't address all of the comparable salaries between other counties because I'm not privy or studied up on that. I don't go to the budget meetings and all of that, so I don't have that information. Oh, David, stop laughing. You know, your office in the past has used provisional lawyers since, yes, maybe not when you were the DA, but before. I can recall situations. Anyway, never mind. I'm not going to argue with you.
Any questions, other questions from the commission?
I have a question / comment. So what was rather unclear to me, and maybe it was my lack of preparation from the last meeting, was that it's really the department's discretion to utilize the provisional attorney program. And so and it was very clear to me at our last meeting that the district attorney was not in support of the proposal. But it's also clear from the letter that we got from Mr. Aaron that he is in support of the program. So from my perspective, since this doesn't mandate individual departments to utilize it, it only provides it, it only makes it available as a tool for each department to consider. I think that, you know, some of the questions we're asking are really in the purview of the management at the department. And so I'm fine. I go back to where I was when at our last meeting. I support it. I think that each of our departmental managers have the ability, the experience, and the professional knowledge to make the best decision for their department. And I'm comfortable leaving it in the hands of the departmental managers. I reviewed the basic, the class spec for the Deputy Public Defender 1 and the class spec for the Deputy District Attorney 1. And they both use the phrase assigned, that the incumbents are assigned low-level misdemeanor cases, and that they are under the supervision of a higher level staff person. So that's all I have to say. I guess there wasn't a question in there. That was just a statement.
Can I say one more thing?
Please.
This reminds me of when the state of California allowed teachers who hadn't completed their student teaching to be hired because there was a shortage of teachers.
And that was the emergency credential program, right?
Yes, yes.
Yeah, I had an emergency credential, yeah.
Okay, so one of the jobs I've held in my career was as a teacher, and I do know that the teacher training program, the student teaching program, was really essential. And it's true that you can take all the courses you want. It's not until you actually do it that you figure out what needs to be done. So I guess with that said, to me, it's an issue of whether or not the county wants to be able to hire lawyers, not fully licensed lawyers, who are going to learn on the job, as opposed to trying to hire lawyers who already have some experience. I would suspect that lawyers with some experience would have more to offer. And so that brings me back again to the applicant pool. Is it that we really need to expand the applicant pool in order to do this? What is the driving force behind wanting to do this?
I have an additional comment. Mendocino County the wages are pretty low. It's universally known. And we become a training ground for people to come, to get their experience. They work for the public defender or the building department or wherever. And once they get a couple of years in and get some practical experience, they move on for more money. We can't retain good employees here. So that has to be addressed in another forum, but it seems like that's going to happen if we approve this description as well. The DA, and if he does, but he probably won't accept a provisional licensed lawyer. But the public defender will train them up and then they'll go. And you just keep losing your labor pool.
But that's a management decision, and that's,
Yes.
in my personal opinion, that's not a civil service commission
Oh, I agree.
decision.
I agree. Just a
So,
statement.
right. So I mean, I totally agree with you. That happens, actually, it happens in a lot of the municipalities within the county also. But if the management in the departments that hire attorneys feel that they have the capacity and the ability to utilize these uncredentialed folks to support their department, then I'm I support it.
It's a management issue, but at the same time, the person on trial is affected by that decision and has no say in that.
I totally
Um,
agree. I totally agree. But again, I mean, the public defender and the DA have their finger on the pulse of what is needed in their department. And I mean, our public defender, Mr. Aaron, is a professional. And so I can't judge or assume that he's going to choose to put an unlicensed attorney in to represent someone that, I mean, their constitutionally guaranteed right of representation, that they're going to, I don't think it's fair to assume that he's going to take a person or an unlicensed attorney to represent somebody knowing that they're not capable. I mean, he's a manager, and he has high, I assume, has high professional standards. And so my assumption is going to be that as a manager, he's going to have the best interests of his clients in mind. And that certainly wouldn't be putting an unqualified representative out there on behalf of him and or our county. So that's kind of why that's my support. That's where my reliance is. And I don't feel like it's my judgment. I don't think it's appropriate for me as a civil service commissioner to judge whether our DA or our public defender are professionally astute enough to determine who they should assign to what case. Is kind of the conclusion I came to.
May I
Bill
just?
Wilson? Yes, go ahead, please.
Yes, thank you.
Marilyn, next.
One thing that people don't understand about a public defender's office is that part of the public defender's office, especially in larger offices, is that the purpose is to train attorneys as well. I know when I started out in the Santa Clara County Public Defender's Office, part of it was to train attorneys, to train them, and they move out and go on either into private practice or into other areas. So it is not unusual, even in larger counties, for public defenders, new ones, to get trained and then move on. So in both and I think Mr. Eister can confirm this also, with younger attorneys, there is a high rate of turnover with young new attorneys, attorney ones and often twos. They come, they get a lot of experience, they get good training, and they do move on. And I think that's something that people need to understand. So it's not unusual for us to train them, and then they do go on and move on to other areas or other career advancements. So that isn't something that's unusual. It's just something that is indicative of our job. And then some come here and they stay because of other reasons, family, or they love the area, or but there's a high rate of turnover in the public defenders, even in the larger cities. So
Thank you. Marilyn?
Yes, my question is, I'm kind of confused here. As if we support this program, this person comes on, are they under the job description? Say the attorney one, or however you would describe, and do we have I don't know, I'm losing something here because we don't have a job description that says a provisionally, attorney here. So a provisional licensed attorney. So I'm kind of confused here. If you bring them in and you put them under the one job description, how does that work? I mean, legally, I don't know. I'm just asking, because I don't know.
Commissioner Hardin, if I could, the recommendation HR made was that because the program is temporary, that we outline the program in the recruitment flyer, but not in the job description. We could change the job description for the temporary program if that's the desire and the direction of the commission.
Do you feel you would have enough legal, recourse? That's the only thing I'm thinking. Do you have enough legal recourse if anything goes awry? And that's, that's not, I'm just putting it out there.
If I believe if the commission approved for us to recruit on the flyer, and that language was in the flyer, that language on the flyer is your backup support, but they would not be unlicensed. They would rather be provisionally licensed, and it will have to have gone through the state's process before they could even be hired.
Okay.
And so they wouldn't be putting an unlicensed attorney in court or even hiring them. They wouldn't even be at new employee orientation until they were approved and licensed. And I think it's an important distinction to make, that provisional license versus unlicensed, and want to be clear, and that they would not be able to be hired unless they achieve that provisional license from the state. And that would be what I would recommend for the flyer.
Okay, and you feel that, and is there a need to do it as Sherry indicated, you feel there's a need to do it now, even though the public, defender's office has said they don't need any at the moment? I just wondered what to kind of watch it for a while. And we haven't heard, and I'd like to also hear from Eisner here too on some of his cons. So
if I could just say one thing before, just to comment on about doing it now, we can't recruit under that unless the commission approves it.
Okay, just to have it in case you need to.
Recruited, he had 8 qualified applicants, 5 of them contacted him for an interview. He's not asking to recruit again right now under the program. What he's asking for is your approval for in the future to use that program if he desires, or any other legal office desires.
Thank you.
Let's go with Terry first, Mr. Eisner. Mr. Pawlowski, still on mute.
I just want to make a statement to see if my orientation to this is right, which we've been talking about details, but this is a program that has been put in place because the usual mechanisms for creating attorneys or making them licensed is somewhat diminished because of the pandemic. And so that is a background to our discussion, which we haven't really mentioned today. And I guess I took away from the last meeting David Eisner's comments, particularly the slippery slope, that he has problems with this whole process as creating a bad precedent or something to this effect. So I'm sure he could address that again. But that is a concern of mine. And Sherry alluded to some of my concerns also with the fact that somebody who is being defended ultimately could be defended by someone who is provisional and not getting the top representation, which is often something which you read about in terms of major cases that get overturned.
Right.
That in some way, their public defenders didn't really do the job, even if they were licensed. So that is a concern of mine.
Thank you, Terry. Mr. Eisner?
Good morning. Thank you for letting me come back monthly. I think we have to understand what the bar exam is. The bar exam is a common foundation of knowledge test. So I know when an attorney comes into my office, and wants to be, well, an applicant comes into my office and wants to be interviewed for a job, I know that that person has a common foundation along with every other attorney in my office. Now, this is an attempt, in some places, there is a problem in recruitment. Okay, that's not the case in Mendocino County. We went over that before. What has happened here, and by the way, Commissioner Popowski, is that you were talking about the system not having access to, say, the bar exam. That's not the case. I have a paralegal right now who is waiting bar exam results, who just took the exam. Now, it wasn't in person. They had to do it online, which is pretty weird. But the bottom line is there are people that are still able to get through that process and take the exam and pass it and not have to do this. So the way I see this, this is a attempt to lower the bar. And we have to remember that the criminal justice system is interrelated. When a defense attorney makes a mistake and a case is reversed, the people that get punished is the prosecution and the victims. That case, it gets reversed, it comes back, and then my office has to decide whether it can proceed a year, two, whatever the distance is down the line. I bristle a little bit when I hear talk about they're only going to be working on minor misdemeanors because, and you heard the list like DUIs. Well, DUIs are not minor. They're public safety risks. Petty thefts, you heard. Victims get stolen from an amount less than $950. They don't consider that minor. They consider that extremely serious. So we don't characterize, in fact, if I'm going to get in trouble on a case with the public, it's probably going to be on one of those, what they call minor cases, because those are what the community sees. That's their experience. That's what they see day in and day out. The business owners, petty thefts, the other folks around, they don't see the murders coming into their life every single day. So I think we have to understand that when the public defender says, there's been no negative feedback from the state bar and Supreme Court, well, that's a little bit misleading. Of course there hasn't been. This was a program that was put into place on October 22nd. I think this commission knows that it takes times for things to go through the process, and you won't see any negative feedback on this for probably a year. So, a month down the road, 2 months down the road, okay, there's nothing yet because we're still having these sort of discussions. I think, I said before, I'll say it again, that my poll of my attorneys and my assistant DA, 100% were against this. They thought it was a diminution of the talent. The person shows up with maybe a scarlet letter that they're not as good as the other attorneys in the office. They'll be perceived that way. Yet, even though they don't have that common foundation of knowledge, they're going to get the same pay as someone else who's gone through the full and rigorous vetting that occurs when you go to law school, that you take the bar, and then you show up for your interview. Let me give you a local example. When we talk about that we're waiving licensing for otherwise qualified candidates, the only otherwise qualified candidates are basically people that have passed law school. So down in Santa Rosa, we have Empire College of Law. Empire does not require its folks to have an undergraduate degree. You can come in there and have been a house painter, take the night courses, and you come out of it and you don't have the same qualifications that other people have. Now, that's, of course, a decision to be made. You decide whether an Empire degree is as pertinent as others, but you also have the test of the state bar that shows that this person has that common foundation. So I think it's wrong to hire someone in that doesn't have those qualifications at the same rate of pay as someone who's gone through the whole vetting process. This thing about salaries being a problem for attorneys, that's a red herring. I was very surprised a year or so ago when the county stepped up and gave the attorneys approximately 36% pay increase over 3 years. So HR will know this, but I think we're only within 10% of the mean average of the counties that we compare against. So we're right in the middle of the mix, and that has done nothing but increase the applicant pool and people that want to come here. So when we talk about salary being an impediment to hiring, we're probably back 2 or 3 years, and we're not in the current state of where we are. So I kind of wish I could just put on redial all the comments and questions that we brought up and discussed at the November 18th presentation, but we don't have time for that. I'm going to look at my notes really quick if I can. I agree that this is a discretionary thing, and one department can do it, another one doesn't have to. But my concern is it's basically doubling up staffing on cases. So it doesn't seem, if your goal is to be a training office, okay, great. But if your goal is to deliver legal services to defendants in Mendocino County, I don't know how this helps. How does this person go out and talk to a defendant, say at the jail? Let's say they're zooming in to talk to defendant. You always have to have 2 attorneys there as you discuss the case and the likes. So this, to me, this is a bad idea. When we start talking about, the public defender talked about Contra Costa County. Contra Costa County is nowhere close to Mendocino County. Contra Costa County DA hires people only on 2 years contracts. They hire people, they'll hire 30 people for 2 years. And then at the end of that 2 years, they slough off basically 2/3 of those people, keep 10, and then they go to the next, what they call class that goes through. And every one of those people that get sloughed off and aren't put on permanent are now out in the market looking for jobs. So there are applicants out there. I just don't know where the public defender is advertising, but we are on the same pay scale as they are, and we're not having a problem. Let me tell you this also, finally. The publicly paid defense attorneys, so the alternate defender and the public defender, have more attorneys than the district attorney, yet handle only 75% of the caseload. So this is stats that we run off on our computer all the time. And so they have more attorneys and less caseload. So I don't understand this staffing need that they have. And so I brought this up many times with the CEO, and the issue it's something that happened 12 years ago or so, where this was allowed to turn upside down. But I just think this is a bad idea. I do believe it's lowering the bar. I believe it's a scarlet letter on the people. They're not going to be considered the same as a normal attorney. I just think it's a bad idea. So I think Commissioner Popowski referred to it as a slippery slope. It's gotten slipperier as far as I'm concerned.
Thank you, Mr. Eister. Anyone else?
Yeah, I just want to say one thing, which is what Mr. Eister referred to is that when someone passes the bar, it's a indication that they have a certain base work of knowledge that the office hiring that person can assume. And without that, then you're just relying on that applicant's coursework. And coursework from institution to institution varies tremendously. I mean, some coursework can be really rigorous and other at different institution less so. But the bar seems to kind of be the playing field that levels that. So that's why it seems so important to have that as part of the criteria for hiring. That's all. Thanks.
Jerry, Mr. Schurz, morning.
Good morning. I just wanted to provide some information on the salaries because it has come up. Currently, the salaries for the attorneys are at around 92% of market. Next year, with the market increases and the COLAs, they'll be really close to 100% of market. I just wanted to put that out there. So the what the county has done in the last couple of years has really certainly put our attorney salaries at the market level.
Good. I'm glad.
Thank you. Mr. Eister?
No, I think that I agree with what was just said. That is where we are, and it's dramatically improved. And so in the past, where we had less attorneys willing to take something to get in the door to move elsewhere, our salary structure is now where they're willing to stay. And in fact, I have people reaching out to us to seek employment. So, part of it is reputation, part of it is opportunity, but I agree with Commissioner Ebian about the foundation. And by the way, in an attorney interview, you never get into coursework. You can never figure out what your coursework is or not. They never come in with a transcript of their courses saying, here's what I took. Right. Best what you can do at that point is they have a good interview or they don't. And that should not be the standard.
Thank you. Anyone else? What's next, Johnny? Move to approve or?
Need a motion.
Well, I'll move to approve waiving the licensing requirements in order for county departments to participate in the temporary State Bar of California provisional license programs without modification to the class specs. There's no second, so somebody else has to come up with another motion.
I will. I'll make a motion to deny the utilization of a provisional licensed lawyer program in the county.
I'll second.
Do we even need a motion? I mean, if we didn't have a motion, would it just die for a lack of action? I don't know. Johnny, I would ask.
Probably.
Okay.
I think so.
Yeah, I think so too.
Okay.
You're on mute, Johnny.
Johnny, you're muted.
You do have a motion and you do have a second, so you can
Okay.
take
That's
action
no
on that. If you need Shelley to repeat it, she can do that.
No problem.
So Sherry has the option to withdraw the motion, and then the previous motion dies because it didn't have a second. Is that correct?
Yes.
Brett,
But it doesn't say what we actually want. It just says we don't want that. And I think this motion says this is what we want. I think that's important.
That's fine. I will repeat my second.
Roll call.
do roll call. Chair Ward,
Yes.
Commissioner Poplawski,
Yes.
Commissioner Evian,
Yes,
Commissioner Beth Michelle,
No,
and Commissioner Harden.
Yes.
So I don't know if it's Shelley as the clerk or if it's Chair Ward as the chair that announces that the item passes. Do we need that public announcement that it's passed by a 4-1?
well, it didn't pass.
I mean, the motion passed.
Motion passed.
The
motion
motion
passed.
passed 4-1.
yeah.
Agreed.
Okay, we'll report out of closed session then. Is that correct?
No, we're not in.
No, this is not
We're not?
close.
Oh, okay. Sorry.
Yeah.
The motion was made not to approve the State Bar Provisional Licenses Program, and it passed 4-1.
Okay.
Right on.
Thank you.
Number 7.
May I wish you all, Commissioners, may I wish you all a happy holiday and be safe.
Thank you.
Yay, thank you.
Thank you, and you
You
as
too,
well.
sir. Thanks for your service.
Thank
you.
you.
Thank you.
Thank you very much for your time.
Same to you.
Thank you.
Same to you. Thank you.
Okay, other business, we have none. We'll move on to agenda item number 8, Human Resources Director Report.
Yes, good morning, Commissioners. I don't have a whole lot going on here as a report. I do want to let you know that the HR just implemented a restructure of our department. The previous model of our department was to have a number of generalists that were relied upon to handle multiple functions within HR. And so what we've done is we've moved into a new structure and support model that breaks down our services into 5 different functional areas: benefits and disability management, recruitment, classification and compensation, employee relations, and workforce development. And so this change in the structure will increase subject matter expertise in each of those areas and improve consistency and improve service. And I think what you'll see in the coming year because of this is that I think we have a number of classification studies that we have on the books and in queue. And I think having one functional area, and that's Johnny's heading up the classification and compensation area. And so we have dedicated staff for that. And so you're probably going to see a number of those class studies and the results of those coming before you in the next year. So we're excited about making this change. I think it's a really good change, not only for the services that we provide from HR, but also giving opportunities for our staff to be more, gain more expertise in certain areas. So I think it's a win-win in that area. Other than that, I just want to say happy holidays. Have a safe and healthy holiday season, and looking forward to a whole new year next year. Hope it's nothing like 2020.
Thank you.
Yeah, here, here.
Okay, meeting adjourned. Thank you, everybody.